Songa nyuma.
Wageni nje kwanza.
Haenda mpaka juu. Kwa nini hivyo? Sogeni hapo. Enda mpaka mwisho. Wewe. Kaa wengine hapo.
Hold her brief. Miss Savala, have a seat so that we save time. I do not intend to. Where is your colleague? You're here. It's okay. It's been a long day. Advocate, I have been exposed to the pronouncements made by the Court of Appeal in the case of Michael Juma Oyamo and another, where the learned judges of the Court of Appeal had made a relevant observation. I think it's paragraph 19, reiterating their pronunciations on the constitutional and statutory principles regarding bail in the case of Republic versus Nuseiba Muhammad Haji Osman, that denial of a constitutional right is not a matter to be treated lightly, and therefore any claims made by against an accused person aimed at curtailing the constitutional right to liberty must not be made on speculation or conjecture. So the onus was on the police to demonstrate why such a large number of respondents, in this case 56 people, should be denied their constitutional right to bond or bail. I dare say they must give compelling reasons applicable to an individual suspect and not a blanket reason, because the constitutional right to bail is an individual right as a human right, and blanket statements cannot apply. So when you look at the miscellaneous application number 2246 of 2024, the applicant seems to acknowledge that some stolen items were recovered from the respondents, but the applicant does not disclose the particular respondent in question. I dare say in that case, he has the basis of bringing a holding charge in line with the directions issued in the case of Michael Rotich. Concerning those respondents, he was able to recover what he deems to be stolen items. For miscellaneous case number 2247 of 2024, it has been disclosed that the perpetrators were arrested at the scene of the various buildings that were burnt, and therefore again the applicant should approach the case in line with the directions given in the case of Michael Rotich above. And in all these three applications made, I have to agree with the counsels for the respondents that the applicants have not demonstrated why the respondents should remain in custody while they conclude their investigations, specifically what part of the investigations would necessitate the respondents to remain in custody, or how the respondents are likely to interfere in the said investigations. And indeed, under the Constitution, all offences are bailable. So the applicants have to ask themselves whether they have provided compelling reasons to satisfy this court as to deny the 56 respondents their individual constitutional guarantee as to the right to bail. And again, the case of Michael Juma Oyamo illustrates that indeed the applicants have not provided any compelling reason for granting the orders sought, because the phrase compelling reason would denote reasons that are forceful and convincing as to make the court feel very strongly that the accused person should not be released on bond. Their bail should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standards that have been set by the Constitution. So that these three applications combined are declined. All the concerns of the state can be accommodated without the very radical measures sought. So I shall proceed to listen to submissions on the question of bail and bond before giving further directions.
You'll be making an application for free bond for all of them. And in the event that the court does not give all the respondents free bond, we'll be making an application for a cash bail for each of them. For 5,000 Kenya shillings. You make that application cognizance of the fact that not a single holding charge has been preferred as against all the respondents.
The issue of the free bond is not something that was canvassed during the arguments when we were hearing the arguments for and against. What was canvassed was the issue of bail and bond. So we will stick with that. And Mr. Gidaiga seems to have conceded to bail, and I think it's also reasonable. But I've also considered the age of the respondents, most of them fairly young, so we'll give them that bond of 5,000 shillings that you have submitted on, with a contact person, one contact person. The 7th and 6th, 13th, 14th and 24th respondents be accorded immediate medical attention. And matter can be mentioned on the 9th of July for confirmation on whether those investigations have been concluded. Any other issues? I think.
Which media station?
Nation.
Yeah?
Nation.
So you'll do a very good report. Huh? Thank you very much. My name is Vincent Gidaiga. I'm a council member of the National Law Society of Kenya. I'm joined by my very able team, members of the Nairobi branch. We have two of them, council members of the Nairobi branch. Former council member together with other lawyers. Today, we've just from court. We had a matter today where 56 suspects were arraigned before court. The prosecution made an application today. Earlier on today, we were just served in the afternoon, around 1 p.m. or thereabouts. In that application, they were seeking to hold the suspects for a further 14 days, pending investigations, within which time in the application they say that they were to collect evidence to make it solid enough for them to arraign our clients and charge them for various acts or various offenses as laid down under our laws, especially the penal code. We've managed to argue that application. We made the rival oral applications this afternoon, and we are happy to report that after the very heated arguments in court. We've managed to have all the 56 suspects released on a cash bail of 5,000 with one surety. So what that means then, therefore, is that whoever has the 5,000 can pay today through the judiciary system, the electronic system of the judiciary, and they'll be free to go home. We'll be coming back after a lapse of 14 days, that is on the 9th of July, 2024. So that on that day is when we expect probably the prosecution will have firmed up its case and probably prefer charges as against the suspects. Until now, they are still suspects. They are not accused persons. They will become accused persons once and if they are charged for particular offenses by the prosecution. So it's a win for the Constitution. The magistrate really laid down a well-reasoned ruling, quoting provisions of the Constitution and also the decisions by the superior courts. And we are very happy, and we applaud the learned magistrate for that ruling. So it's a win for democracy, a win for our Constitution, a win for Kenyans, a win for us all. Thank you very much.
Thank you once again. My name is Ochieng Gor, a former council member of the Law Society. Of course, I'm flanked by my colleagues from Nairobi branch. Most of us practice from Nairobi. Today we attended court in the afternoon. There had been 56 suspects who were brought to court. The prosecution wanted to hold them for 14 days so that they can firm up their case and charge them. We vehemently opposed that application, and the court agreed with us. And the suspects have been released on a cash bail of Kenya shillings 5,000. We are here on behalf of the larger Law Society of Kenya. We have lawyers stationed across all courts in the countries where the various suspects have been taken. So LSK is fighting for the rights of Kenyans and for the rule of law. So let no Kenyans languish. Wherever they are, they can reach their local branches. We have 8 branches across the country. So that lawyers will be doing this on pro bono basis. Nobody is paying us. We are doing it as part of our work to the nation and to the country. So we thank the lawyers that came out today. We also thank the court for making such a reasoned judgment, because in this time and age, you cannot just arrest people then find charges later. So the court agreed with us, and the suspects have been released. Yeah, no charges. The charges, there was no holding charge. What they said that they were saying that there was an arson, but they did not give us names of particular places that had been attacked. They were saying also there were breakages, people broke into shops, and some were arrested at night. So those places were not mentioned. And then they were being accused of the fire in Parliament and fire at City Hall and also Supreme Court. But the court said that is not enough to hold the suspects. So the prosecution did not actually bring something that was cogent enough to enable the court make a decision to hold the suspect for 14 days or for any number of days.